Hello and welcome to Larry Talks. I'm your host, Dr. Larry Dean Doyle, and I am really happy you're here. Whether you're listening during your commute, a quiet moment at home, or somewhere in between, thank you for choosing to spend this time with me. So take a breath, get comfortable, and let's get into today's session. Today I want to talk to you about something bigger than a chemical, bigger than a scandal, bigger than any single agency. I want to talk to you about the rule of law. It's not a slogan, it's not a political argument, but as the system that allows ordinary citizens to question the government that governs them. Because when a government chooses secrecy over transparency, when it chooses narrative over documentation, it is not just protecting itself, it is weakening the mechanism that keeps a free society accountable. And nowhere is that more visible than in handling of Agent Orange on Okinawa. The rule of law is not protected by press conferences. It is protected by preservation of evidence, transparency in records, honest compliance with court orders, equal treatment of citizens. It depends on three pillars: transparency, honesty, and equality before the law. When any one of those pillars weakens, the system takes a hit. Not dramatically, not all at once, but incrementally, quietly, structurally. Let's be clear about something. We're not discussing troop movements. We're not discussing classified intelligence sources. We're not discussing current operational vulnerabilities. We are discussing events that occurred nearly half a century ago. When a citizen requests documents and learns that during the Vietnam War, Kadena Air Base on Okinawa functioned as a corrosion control and aircraft cleaning facility, that is not a national security threat. It is a historical fact. Aircraft that operated in herbicide spraying missions were flown to Kadena. They were washed down, and we now know that standard washing procedures did not eliminate dioxin contamination. Paint was stripped off of those aircraft. That paint residue, contaminated material, was washed into drainage systems, into soil, and eventually toward groundwater in the ocean. This is not intelligence disclosure. This is not environmental accountability. When 18 aircraft potentially contaminated with herbicides were slated for destruction, despite being covered under a federal preservation order, and the court was not notified, that is not classified information. That is procedural noncompliance. When in 1981, a memorandum circulated within the White House referencing a toxic Agent Orange dump, and the author explicitly stated that the court should be notified, and the court was not notified, that is not a state secret. That is a breakdown in adherence to judicial authority. These events occurred 46 years ago. There is no national defense value in concealing them today. There is only institutional protection, and when national security becomes a reflexive shield for decades-old administrative conduct, the ability of ordinary citizens to question their government is diminished. In 1979, federal judge Jack Weinstein issued a preservation order in Agent Orange product liability litigation. The order required federal agencies to preserve all documents, data, and tangible evidence relating to Agent Orange. Not selected documents, not convenient documents, all documents. Preservation orders are not symbolic. They're binding. If aircraft are destroyed without court notification, if shipping records disappear, if contamination events are not disclosed, then the rule of law absorbs another quiet blow. For more than half a century, the official position has been simple. There was no Agent Orange on Okinawa. Not uncertainty, not partial acknowledgement, a categorical denial. Yet I am in possession of a certified government shipping document dated 1966 that shows a shipment of 2,4,5-T herbicide leaving Chicago bound for Machinado, Okinawa. Machinado, a known U.S. logistics hub. This document was certified by the Department of Veterans Affairs. It has been used in exposure determinations. It is described as the only remaining copy. That raises a serious question. If there was no herbicide on Okinawa, why does a government-certified shipping record show 245T going there? And if this is the only surviving copy under a federal preservation order, where are the others? If everything was above board, why were the rest destroyed? Preservation does not fail by accident across an entire category of records. 4 barrels were unearthed on land formerly associated with Kadena Air Base. Buried in those locations, veterans had described, corroded, marked. For decades, veterans said they saw and handled herbicides. They described storage areas. They described burial. They described leaks. They described defoliated zones. Are hundreds of veterans mistaken? Or were records incomplete or selectively preserved? In any court of law, consistent corroborated testimony carries weight. In this case, it was met with categorical denial. Each of these instances represents a small deviation. Shipping records reduced to a single surviving copy, aircraft destroyed under preservation coverage, court notification not made, contamination minimized, veterans dismissed. No single event collapses the rule of law, but repeated deviations erode it. The rule of law is not lost in one dramatic moment. It erodes when transparency becomes optional, honesty becomes managed messaging, equality before the law becomes conditional. This is not relitigating Vietnam. It is about whether ordinary citizens can question the government and receive full, preserved, accurate records in response. It is about whether courts issued orders that must be obeyed. It is about whether veterans are treated as credible witnesses. It is about whether correction is possible when documentary contradictions emerge. Because the rule of law does not require perfection. It requires correction. If a certified shipping document shows 245T bound for Okinawa, if barrels were unearthed where veterans said they were buried, if preservation orders existed, then the appropriate response is reassessment, not denial. The veterans who served on Okinawa did not ask for the privilege. They asked for fairness. They asked for preserved records. They asked for transparency. They asked for equal treatment under the law. That is not activism. That is citizenship. The rule of law is not tested when everything runs smoothly. It's tested when evidence is inconvenient. Okinawa is not merely about herbicides. It's about whether the law binds institutions as firmly as it binds citizens. But because when preservation becomes selective, when documentation becomes singular, when testimony is dismissed, the system does not collapse loudly. It erodes quietly. And erosion is harder to see, but its consequences last far longer. As I wrap up tonight's episode, I hope it gave you something to think about, and maybe even something to carry with you and think about. If this session resonated with you, please feel free to share it with a veteran or dependent who is suffering, or someone that might need to hear it, or someone who may be interested in this topic. And don't forget to click on the follow icon so you don't miss future episodes and sessions.